Governor Whitmer's executive orders now thrown out by the Supreme Court. We talked to the woman who argued the case in front of the High Court. Let It Rip Weekend starts right now. And it's time to let it rip. Well, we're going to get to that debate in a moment. But first, some in the state still in shock over the Michigan Supreme Court's decision to throw out Governor Gretchen Whitmer's executive orders. Joining me now, she is an attorney with the group Restore Freedom, also the host of the political talk show The Fifth Chair, and she argued the case in the Supreme Court in favor of getting rid of the governor's orders. Attorney Katherine Henry is here. First of all, thank you. I guess congratulations to you for winning. But let's clarify some of this very difficult 100-plus opinion case. First, the way I read the opinion, it seems to me that the Supreme Court's decision was a 7-0, unanimous on the issue of whether the governor has authority. And I think the court said the governor does not have any authority at all to issue executive orders after April 30th. Am I right?
Yeah, specifically, they said that she has no authority on a 7-0 opinion, no authority to issue these executive orders according to the Emergency Management Act of 1976. That was the first part, and that was the part that was unanimous, that she has zero authority under that 1976 law to do this.
So now the governor issued a press release saying that the decision was 4-3. Can you clarify what that means?
Yeah, so the second half, there were two questions that our Michigan Supreme Court was answering from the federal court case. The second question was whether the Emergency Powers of Governor Act violated the state constitution, namely the Separation of Powers Clause, Article 3, Section 2. And so what the court said in a 4-3 opinion in that regard was that, yes, the Emergency Power of Governor Act of 1945 is entirely unconstitutional. So therefore, the governor has no way to rely on that as a source of authority to act on our behalf.
So I don't want to get too much in the weeds right now, but the 7-0 decision, the unanimous decision then, all the justices agreed the governor does not have the authority. Could you just explain what the rationale was for the 7-0, the unanimous decision?
Yeah, so the governor has had some very creative reading skills when it comes to our state laws here in Michigan and the Constitution. The 7-0 decision specifically said that the legislature has to be involved after 28 days according to the 1976 Emergency Management Act. So they did give that first extension on April 7th. They voted to give her another 23 days. And so after April 30th, the only way that her orders could continue is if the legislature voted to extend the state of emergency yet again, which they did not. So the court in 7-0 decision said that very clearly the governor had to get the approval of the legislature to go beyond that initial 28 days, and she would have to get their approval in order to go beyond any first extensions that occurred through April 30th. And they did not vote to extend, so she didn't have the power.
So then, as a practical sense, does the Supreme Court's decision mean that we don't have to wear masks anymore? We don't have to social distancing? Any of those? We can go to gyms and nightclubs and strip clubs and whatever we want? Is that what I'm taking from this?
Yes, absolutely, 100%. That means burn your masks right now if you didn't already. Open your gym, open your movie theater, open whatever business you have. Go and frequent whatever business that you would like to go to. If you have a church that's limited your services because of how you're reading the executive orders, forget that. All of those executive orders based on COVID-19 circumstances from 2020, they're out, they're gone, they're done. There's nothing in place anymore in terms of these executive orders from the governor. And there's been, she's been saying that, well, I had this 21 days. There's two court rules that possibly would come into play. Number one, if she's asking for a rehearing, but she actually, in order to trigger anything, she has to timely file something first. She hasn't filed anything. And me, being one of the attorneys on the case, I would get notification as soon as she filed it. There's nothing come through yet. But also, really what it would probably be is the motion for reconsideration, which the rule on that is MCR 7.311G, which very clearly says the filing of a motion for reconsideration does not stay the effect of an order addressing a motion. And I mean, let's look at Marbury versus Madison back in the 1800s. If we have an unconstitutional law or government action based on an unconstitutional law, we don't have to follow that. It's void. It's void right from the start. So absolutely, throw your mask away right now.
So let me throw the masks away right now. The governor issued a press statement, though, that was pretty clear that she says her orders are in effect for 21 days. So just so I'm clear, you disagree with the governor that her orders are done as of today, not 21 days?
They were done as of Friday at 4:35 p.m. Absolutely. 100% certain on that.
Can the governor appeal this decision?
No, she can't appeal it because the only thing higher than the Michigan Supreme Court would be the United States Supreme Court. But on this particular issue, the only issues in front of this court were specifically about state law and state constitution. And did she violate state law? And did our state law violate our state constitution? Our United States Supreme Court doesn't have jurisdiction to hear those kinds of cases. They could only answer issues about if our state law or our state constitution violated the federal law or federal constitution. So the highest court in the land that can answer these questions has spoken. The decision has been rendered. It's there as of Friday at 4:35 p.m. So she can try and whine and complain all she wants. She's not going to get anywhere because there's no legal remedy for her to do that.
She cannot go to the U.S. Supreme Court. That is not an option for her?
That is not an option for her in this particular case over these particular issues.
Okay, again, I don't want to get too much in the weeds, but my understanding that a federal court asked the Michigan Supreme Court essentially for an opinion as to whether or not her executive orders were constitutional. Doesn't the decision now have to go back to the federal judge? And doesn't that federal judge have to do something?
Yeah, so the federal judge, all he's going to do is take that information and plug it into his case to decide if he can clear up or settle that case, resolve that case without having to touch the federal court issues, the federal statutes and the federal constitutional provisions. And I believe based on the order that he gave in June, that's what he's going to do. That judge doesn't have to approve of what the Supreme Court in Michigan did. The judge simply said, you know what, we don't have this issue resolved by the highest court in Michigan on these state issues, so the judge is going to take it at its face value, whatever comes from the Michigan Supreme Court. Well, that judge is not going to be able to do anything about that decision other than accept it.
And that can't get appealed to the federal appeals court either?
No, because the federal courts have no jurisdiction over whether a governor in Michigan violated state law or whether the state law violated our state constitution.
All right, let me just get you real quick. I got time is here, but today, Oakland County, the health director issued an order to wear masks. Do you anticipate any challenges to the local health director, at least here in Oakland County, issuing this order to wear masks?
Oh, definitely. And I will definitely be one of the attorneys involved. I would hope a lot of other attorneys are going to step up and say no and fight it. That's done under the Public Health Code, and that's why I wrote a constitutional amendment called Restore Freedom Initiative. We need signatures to stop all of these horrible laws. But in the meantime, we'll keep fighting whatever other legal path we have, which will be bringing counties like Oakland County to court and fighting those unconstitutional orders.
I tell you what, we could go on and on. This is fascinating stuff, but I think we learned a lot today. Katherine Henry, attorney who actually argued the case in the Supreme Court on this very issue. I thank you for clarifying a lot of very confusing issues here. All right. Hold the thought. We got a lot more to debate. We're going to return with our panel. We're going to talk about this. We'll talk about the race to the White House. We've got a lot more coming up on Let It Rip.